Yes. Of Black Bank pay you are for the
claimant, my lord.
mm-hmm.
The claimant, my lord.
All right. Yes.
May please, my noble lord.
Mm-hmm.
That's all say sir. I we are here for the defendant.
You said who? I can't hear you.
Oluwatosin Adisa.
Mm-hmm.
Respectfully call the defendant.
Mm-hmm. All right. That's the Echo Bank case. You have for Echo Bank.
Yes, my lord.
All right. So, please, can you kindly adopt because we're a little bit out of time. The court was on vacation, and then eventually the court was bereaved. So I've not been around for some time. Did you hear me? Hello? Can you hear me?
Yes, my lord. The claimant filed a written address dated the 15th day of April 2024, my lord.
15th day of April.
Adopt the claimant final written address as the defendant's arguments in support of the claim, my lord. We humbly urge the court to grant the release of the claimant as per the claimant's claim in this matter. Thank you, my lord.
All right. Yes.
My lord.
Mr. Adisa?
Yes, my lord. Following the close of trial, defendants filed the final written address dated the 7th of February 2024. My lord, in reaction to the claimant's final address, we also filed a reply on points of law dated the 16th of May, 2024. I most respectfully readopt
16th day of
16th May, my lord. I readopt our final written address of 7th February 2024 and the reply on points of law of 16th May 2024.
All right. So, with your permission, I would, an understanding, I'd love to read the operative part and then go to the decision part. In the National Industrial Court of Nigeria in the Lagos Judicial Division, holding at Lagos, today, the 18th of October 2024, in suit number LA/136/2020, between Charles Chukwudi Nwobi, Adegoke Olabaji Ajibola, Sani Shuaibu Adamu, Adeshina Muhyiddin Barua, Michael Uba Ogebe, Agbo Elemi Agbo, Mrs. Teresa Kehis, personal representative of the estate of Richard Chukwuweke Kehis, the deceased, and Ecobank Nigeria Limited. The representation was by Abiodun Olagbampe with the Uche Nwachukwu for the claimants and Oluwatosin Adisa with Oluwatola Akindura for the defendants. Now, I'll go to the decision part of the matter. I've gone through the processes filed at the argument of counsel, as well as the evidence of witnesses brought forward. I've taken into cognizance the issues raised by counsel for this court to effectively determine this suit and distill these issues into three. One, whether the claimant's suit as presently constituted is proper. Two, whether the claimants have proved wrongful termination. And three, whether the claimants are entitled to the relief sought against the defendant. On the first issue raised, the defendant has raised an objection that the claimant's suit is improperly filed as the claimants have different reliefs and ought not to be joined in one suit. Order 13 Rules 1 and 11 provide that persons may be joined in a suit where reliefs exist jointly or severally, and that such persons may sue in a representative capacity. Now, while the claimants in this suit have not sued in representative capacity, they have one common cause of action, that they have not been paid their full benefits by the defendant. They will also outline their individual entitlements they seek against the defendant and tendered their respective documents in proof. Now, the defendant would rather the court have several separate cases filed with one common cause of action can be filed. Claimants have filed their respective letters of employment, letters of termination, and the court will handle this contract of employment as they relate to each other, to each claimant individually with their nuances and differences and also their entitlements, if any. I find and hold that this objection has no bearing on the outcome of this case. It is but a technicality that cannot extinguish the jurisdiction of this honorable court. On whether the claimants have proved wrongful termination, it is right that where a party seeks a relief for wrongful termination, the onus lies on him to prove same. See University of Calabar and ACN 1996 by Muhammad JSC at page 56 to 57, paragraphs F to C. The claimant has the burden to plead and prove the following: that he is the employee of the defendant, how he was appointed and the terms and conditions of his appointment, who can appoint and remove him, the circumstances under which his appointment can be terminated, that his appointment can be terminated by a person or authority other than the defendant. See also UTC Nigeria PLC, and just a second. The main ground of the claimants, however, is not gratuity, but severance pay. Claimants counsel argued that one Erame Peter Ebada was terminated under similar circumstances and paid both gratuity and severance pay. This court cannot rely on this letter of termination as the facts of Erame Peter Ebada's terms and conditions of employment are not before the court. And as I said above, even though the courses of action of parties are matched, consolidated, being similar in nature, the court will consider each contract of employment as individual and pertaining to each claimant alone. The main ground of the claimants, however, is not gratuity but severance pay. Claimants counsel argued that claimants counsel argued that the first claimant was advised of severance pay in his terminal letter but not paid, and as such, same should apply to the remaining claimants. Again, this cannot be applied. Counsel has failed to show the court why the defendant's handbook stipulates for severance pay and on what basis same is calculated. To grant this relief as paid by the claimant will be grant a relief based on speculation, and this court must not speculate but reach its decision on the basis of fact and evidence before it. The first claimant's letter of 9th May, which stated his terminal benefits, listed the sum of 5,638,387 naira 35 kobo as severance pay. The defendants have argued that this was a mistake. Hence, the reason he wasn't paid same. There is no letter sent to the claimant correcting this mistake after it was sent. Even when counsel wrote to the defendants, they did not correct this supposed mistake but allowed same to be brought to court. The court relies on evidence before it and not conjecture or argument of counsel. The evidence before the court is that the defendant is owing the first claimant, Mr. Charles Ngobi, the sum of 5,638,387 naira 35 kobo, being his severance pay, and I hereby order the defendant to pay same forthwith. For second to seven claimants, there is no evidential proof for the payment of severance with the calculation of same. I hereby refuse to grant the reliefs as claimed. The court will not grant any per judgment interest on the above ordered sum, but if the defendant does not pay the judgment sum 1 month after this judgment, same will attract an interest of 10% per annum until fully liquidated. I also refuse to grant any monies for general damages or cause of this action. This is my judgment and I enter it accordingly. I hope the audio was good. Hello? Hello?
My noble lord, we were not, my lord.
Yes?
My lord, we could not hear clearly the pronouncement of court in respect of the relief sought by the claimant. Yes, my lord. I apologize. We did not hear clearly the pronouncements of the court.
I believe it's something to do with the audio. So we'll have to pronounce it again because the pronouncement, yes, the pronouncement of the court is very, very important. Yes, so let's read the judgment again.
I thank the court for the indulgence. I'm grateful, sir.
Oh, yes.
Most grateful, my lord.
No problem. It's your right. You have to hear the pronouncement of the court. It's of no moment if you cannot hear the court. Now, confirm you can hear me now.
Yes.
Yes, my lord, we confirm.
Yes, my lord.
Hello? You can hear me now?
Yes, my lord, we can hear me, lord. Very well.
All right. In the National Industrial Court of Nigeria in the Lagos Judicial Division, holding at Lagos today, the 18th day of October 2024, in suit number LA/136/2020, between Charles Chukwudi Nwobi and 6 others, and EcoBank Nigeria Limited, the defendant. Representation was by Abiodun Olagbanpe with Uche Nwachukwu for the claimant, and Oluwatosin Adisa with Oluwatola Akindura for the defendant. Did you hear me?
My lord, loud and clear, sir. We are grateful, sir.
Good. Well, all right. So we'll go straight into the matter. Now I go into the court decision. I've gone.
My lord, the audio was clear on the first issue, sir, that my lord dismissed the objection of the defendants.
Determine this suit and still these three issues, these issues. Hello?
My lord, sir, kindly unmute yourself. We can't hear you. Hello, my lord.
Hello. Hello? Is it clear there?
Hello? Is
My
the
noble
audio
lord?
now good?
Yes, sir. My lord?
Hello?
Yes, my lord.
Akpan, call Akpan for me.
Should I turn on the video?
Can you still hear me? Turn on the video.
We can hear my lord from our devices.
This is a very strange Zoom trial. I can't get Williams. Let me call you. Hello?
My lord, we can hear your lordship from our
You can
device.
hear me now?
Yes, my noble lord.
We can
All
hear
right.
you.
It was off here. A very strange trial. I was trying to get Williams on the phone. So let's give it a one try. One more. Yes. Uh, did you hear the first part, the operative part?
Yes, my noble lord, we did.
Oh, okay. Let me go to the decision part.
Yeah,
Yes,
decision
sir.
part.
Okay,
Yeah.
this is the court decision. I've gone through the process filed and the argument of counsel, as well as the evidence of witnesses brought forward. I've taken into cognizance the issues raised by counsel for this court to effectively determine this suit and distill these three issues: whether the claimant's suit as presently constituted is proper, whether the claimants have proved wrongful termination, and whether the claimants are entitled to the relief sought against the defendants. On the first issue raised, the defendant has raised an objection that the claimant's suit is improperly filed, as the claimants have different reliefs and ought not be joined in one suit. Am I still with you? Can you hear me?
Yes, my lord.
All right.
Yes,
Order
my lord.
13,
Yes,
Rules
my
1
lord.
and 11, okay, provide that persons may be joined in a suit where reliefs exist jointly or severally, and that such persons may sue in representative capacity. Now, while the claimants in this suit have not sued in representative capacity, they have one common cause of action: that they have not been paid their full benefits by the defendant. They have also outlined that individual entitlements they seek against the defendant and tendered their respective documents in proof. Now, the defendant would rather the court have 7 separate cases filed when one with one common cause of action can be filed. Claimants have filed their respective letter of employment, letters of termination, and the court will handle this contract of employment as they relate to each claimant individually, with their nuances and differences and also their entitlements, if any. I find and hold that this objection has no bearing on the outcome of this case. It is but a technicality that cannot extinguish the jurisdiction of this honorable court. On whether the claimants have proved wrongful termination, it is tried that where a party seeks a relief for wrongful termination, the onus lies on him to prove same. See University of Calabar and SCN 1996.
My lord, I'm sorry we are unable to follow any longer. I apologize. We can no longer hear my lord.
I don't think so.
Doubt that the claimants are employees of the
Thank you,
defendant.
sir.
Are you hearing me?
The audio just resumed again.
Yes, my lord, we can hear you.
I don't think this is right, because it is is a precondition for a judgment to be heard, and the pronouncement to be very clear. Where's Williams?
My lord, at this point,
Gentlemen, I don't want
counsel
any issue I don't want this issue to come up in any appeal, because it is after the pronouncement of the court that you get the proper judgment, and then whatever
Yes,
you
sir.
want to do with it, you go ahead. But if you have not heard what I said, then any document can be rejected if it is presented to you as the judgment that the court read.
Well, my noble lord, counsel
Yes.
for the claimant and the defendant are here seated before your lordship. And
I
at
know.
this point, we can hear my lord clearly. We
Mm-mm.
don't mind.
I wouldn't mind this judgment being read even orally in court on Monday. I don't want any surprises.
As the court places.
I don't, because I don't want, because how can you confirm that really it was what the court pronounced that you are given as the judgment of the court?
Well, this is a practice that has come to stay. If my lord is willing to indulge us a final
It's not a
time,
matter of indulging you. It doesn't cost me
as the
anything
court
to
places.
continue reading it to the end, and you have not had me, you've not had me. Issues can come up on appeal. You understand that the judgment
Yes,
was
my
read,
lord.
it was the pronouncement of the court was not heard. There were audio issues. We are not even sure if it is the same judgment that the court has delivered. It will definitely come up. I know that.
That's correct.
So my decision is we are going to review judgment, so that nobody will be in doubt as to what exactly was pronounced in the judgment.
As the court pleases, we remain bound by the decision of the court.
Yes, it's very important. Because justice must be done and also must be seen to have been done.
Very, very well, my lord.
Yes.
Sir.
So, gentlemen, maybe we are all in God's protective custody for being here at this hour. It's not a wasted day. I will tell Williams to give you a date that you come, and then we'll read this document. The only thing that is already in the file is the adoption, and then we are bound by that. Then
As the
we'll take
honorable
it.
court pleases.
Yes.
As the court places.
All
As
right.
the court places.
All right. So,
We thank you,
Williams,
for-
are you there? Yes. Thank you very much for your support.
Yes, my lord.
Williams, are you there?
Yes, my lord.
Yeah. What about the date? The next week. Give them a date next week that we can read it in open court. Very important.
Most grateful, my lord.
Thank you very much, gentlemen. Thank you. I appreciate you. God
As
bless
the
you.
court pleases. Yes,
All right. So it's all right. Mute me.
Third. Yeah. Yeah, most
Convenient.
confident. Possible. Okay, that means coming to Lagos. Yeah. Break. May still happen. Don't appeal on that. Don't.
No, this as copies.
At the court places.
And the second one, first one. The second case, my own case.
We want to adjourn the Lanessi case.
Which is the second one? That is our own case. Well, this was 1st November.
We should be paying interest until that payment is made. This is a positive judgment.
You see what I mean?
Well, and you interpret anyhow. But wait, my own should be transmitted before us by put transmitting.
Okay, that's what I've
Yes, put transfer later. Put the wire. Yes. Put the carton.
No, when you deliver lectures,
Handwriting. She won't project the handwriting.
so you can even like ability it.
Ẹni sọ̀rọ̀ gbọ́ rárá ni àbí
Mo gbọ́ díẹ̀, mi ò gbọ́ tó wọ́ díẹ̀, mi ò gbọ́ dáadáa.
gbọ́ tó mi ò kàn mọ̀ bóyá
Mo gbọ́ àwọn fígọ̀, mi ò gbọ́ nǹkan.
is it pronouncing cars?
No, what she first did was to call it for determine. Since gbogbo common whatever la ní, so we can check it. Then wọ́n ní pé àwa tó affect Charles Ajibola blah 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 blah. They wá sọ pé one denominator to determine case one.